Imagine this. A loved one passes away and leaves behind their home. No will, no trust, no instructions. So by law, their next of kin inherits the property. You expect it to be a smooth process. Then you find out that you're now co-owners of the home with your second cousin's daughter. Or maybe that uncle you stopped talking to 5 years ago because of a political fight you got over Thanksgiving dinner. Not quite ideal, right? Well, welcome to the world of co-ownership by inheritance. It happens all the time in California, and trust me, it leads to a lot of headaches. And what is the most common question we get in that sort of situation? Can they force me to sell the property? Well, yeah, but let's talk about that. Be sure to like the video, share it with someone inheriting a property with their ex-brother-in-law, subscribe for more, and as always, thank you for watching. So, how does this happen? This all begins when someone passes away owning property. Sometimes they plan by creating a living trust, but the real wacky ownership outcomes typically arise where we have someone passing away without an estate plan, no will or trust, and thus their estate is distributed to whoever the probate code says should get it. That means whoever the law says should inherit does, whether they were close to the decedent or not, whether they were equipped to manage real property or not, and whether they get along with each other or hate each other. You now own a slice of this home with potentially multiple other people, none of whom can be forced to give up their interests voluntarily. But you or they can force a sale. If you inherit property with people and can't agree on what to do with it, sell it, rent it, move in, leave it vacant, California law gives you a tool called a partition action. Under the California Civil Code section 872.010, a co-owner of real estate can petition a court to partition the property. Before you roll your eyes any further, let's discuss what that means. It means asking the court to intervene and either, one, physically divide the property, which is rarely used. How do you split a single-family home, for example? Or number two, force a sale and split the proceeds among the owners. Or number three, appraise the property and allow one co-owner to buy out the others at fair market value, which only happens when there's an agreement or settlement, which, if we're reaching this point in the argument, we probably can't agree on a price, and therefore this is also a rare outcome. Thus, for most residential real estate, you're looking at a partition by sale. The property is sold to some third party and the proceeds are split among the owners. Now, let's put this in a real-world context that I see in my practice. A parent dies without a trust, their 3 children inherit the family home. One wants to sell it and split the cash, another wants to move in and figure things out. The third one's off being a free spirit and therefore we can't get a hold of them, or they're just too scared to pick a side. One child might now be stuck paying the mortgage, the taxes, the insurance on a house they only partially own, and the other two, well, they're enjoying the ride without having to lift a finger. This is where partition becomes not just a legal option, but unfortunately a necessary one. A partition action is not an instant fix though. Make no mistake, it's a lawsuit. You're dragging your co-owners to court. They'll need to be served, you'll need to pay court filing fees, hire an attorney, maybe a referee to handle the sale, possibly an appraiser as well. It takes time, it costs money, and if emotions are already running high, which they usually are if we're in this position in the first place, you might end up in a full-blown trial over whether the house should be sold or not. So yes, you can sell, but you might have to go through a full-on court battle just to do it. Let's flip the script a little bit. What if the person who passed away had created a revocable living trust? What if they had put the house into the trust and named one person to inherit it or instructed it to be sold and the proceeds divided? Well, of course, there'd be no fighting, no co-ownership, no partition lawsuits, just a clear plan, a clear title, a smooth administration. You see, all these problems can be avoided with proactive planning. But when that doesn't happen, we're left in a reactive mode essentially, cleaning up the mess after the fact. Sometimes it gets a little stranger though. Let's say your cousin passes away. They had no trust, no will, and you're one of several heirs. Now you've inherited property along with the people you've never met. That house you now own a fraction of, well, you can't rent it out without their approval. You can't remodel it without their signature. You can't even refinance it or really pull equity from your share. Okay, I suppose legally you would have the power to sell your portion of the property, but realistically, who's going to buy your 1/6 share in a single-family residence? Yeah, thought not. And if they move in and you want out, well, you're looking at either a buyout or filing a partition action and forcing the issue. That might involve hiring a lawyer, serving your co-owners, waiting months for hearings, paying legal and court fees, and of course, risking resentment and backlash from other people in the family. All because someone didn't plan or some people just don't get along. And this is why an inheritance is not always a blessing, or at least it may not feel that way in the beginning. Without a plan, your heirs may inherit real property, but also inherit debt, responsibility, and the big one, conflict. And for those of you watching who are already stuck in this situation, a partition action may be your only way forward. But if you're not yet in this boat, don't wait to plan. Talk to an estate planning attorney, create a trust, decide what happens to your house and who gets what. Spare your loved ones the drama of co-ownership with strangers and lawsuits. If you've inherited a house with people you never expected to co-own anything with, and things are getting a little tense, then you're not alone. These situations are common, and while the law gives you a way out, it's never as smooth as just having a solid plan in the first place. Of course, you should talk to an attorney before trying a DIY at negotiation and/or a partition action, leading to an even larger mess on your hands. But for now, if you have any questions or a topic you want me to cover, let me know down in the comments below. If you know someone who stands to inherit property with people they may not want to own property with, then please share the video and give it a like on your way out. I'm attorney Andrew Bethel, and I'll see you at our next meeting.